Welcome to the debate. Imagine walking onto a battlefield armed with nothing but, heartfelt poetry, only to find out your opponent is driving a tank.
Yeah, that is not going to end well.
No, not at all, but that is exactly what it's like walking into a courtroom as a layman. I mean, you argue fairness, morality, and your absolute truth, but the system just, it doesn't care about your poetry.
Right. It speaks a totally different language.
Exactly. The system argues forms, procedures, and jurisdiction, and the tank wins every single time. So today we are digging into a fascinating operating guide from our source material on how to actually survive this legal machinery. We're really going to focus on what is in the source and break it down for the layman.
Which is so necessary.
It really is. The core issue we are tackling is how a layman can effectively convert the raw moral truth into a language the court is basically forced to respect. I represent the position that strict, real-time adherence to the procedural chain, forcing the court to prove its authority, its standards, and its facts, step by step, is the layman's absolute best and frankly only practical shield.
And, I look at that exact same machinery and see a completely different, fatal flaw. I mean, while procedural mechanics are undeniably necessary, focusing on them exclusively sort of ignores the actual engine driving the tank.
How so?
Well, if you don't confront the deeper structural rot of the tribunal itself, specifically I'm talking about the financial incentives, the institutional revenue paths, and the docket speed pressures, then mastering the microprocess is just playing a rigged game.
You're saying the rules don't matter?
Not exactly. I'm saying you might learn the rules perfectly, but the referee is getting a cut of the ticket sales.
Okay. Well, let's start with what is actually happening in the room, because the material asks a really profound question. What are they doing that we are not doing? And the answer is process.
Right.
The system wins not because it possesses some, grand moral high ground, but because it uses labels, presumptions, and timing. Most people walk into a court and ask these broad, morally loaded questions. They yell, "Where are my rights?" Or, "This whole thing is illegal," or "That cop is lying."
Which are all valid feelings.
Sure, those statements might be perfectly true in reality, but procedurally, they are completely weak. They give the tank nothing to hit. The system doesn't need to prove a worldview. It only needs to move your case to the next step on the conveyor belt.
Right, and it moves that conveyor belt using a very specific language that, frankly, most people simply never learn.
Exactly. It uses a procedural chain reaction. And we need to break this down for the layman, not just list it so we understand how it actually works. Think of the legal standard as a physical bridge you have to build to get to a ruling.
Okay, a bridge.
Yeah. First, what gives the judge the power to even hear this issue? That is the authority. Second, what is the specific rule we are measuring my actions against? That is the standard.
Got it.
Third, what actually happened in the real world? Those are the facts. Fourth, how do those specific facts meet that specific standard? Those are the findings. And finally, what is the scope of the ruling based on all of that? I mean, if you don't test each plank of that bridge, it collapses.
Okay, let's make this real for a second. Let's look at a concrete scenario to see how this plays out in practice. Say a police officer writes a report stating you looked, quote, suspicious outside a storefront. Happens all the time, right? The judge reads it, looks down from the bench, and says, based on the evidence before me, I'm finding a safety concern and ordering you to standard probation.
Yes, perfect example. In that moment, a layman usually panics and yells, "I wasn't doing anything wrong! The cop is lying!" which accomplishes absolutely nothing.
Just noise to the court.
Exactly. The judge bangs the gavel and you are on probation. But mastering the procedural chain means you calmly step in and ask, is the court treating this unsworn police report as a mere allegation or as established fact?
Wow. Okay.
Yeah, you are stopping the tank in its tracks right there. You don't let them skip the planks. You force them to say, out loud, how a piece of paper magically transformed into a proven fact without any foundational evidence. You basically break the paperwork spell.
Right.
You can't just stand on the riverbank shouting that the bridge is corrupt. You have to point out exactly which planks are missing in real time.
Look, I hear you on the paperwork, and I absolutely agree that pointing out the missing planks is a really smart, immediate reflex. But you are assuming the judge actually cares that a plank is missing.
Well, they have to under the law.
Do they? What if the judge owns the bridge? What if the bridge is actually a toll road and the municipality gets paid every time someone is forced to cross it?
This is exactly where your analogy falls short for me.
But that's a huge accusation to make in a courtroom. It is, but the Supreme Court actually agrees with this concern. I mean, in cases like Tummy or Ward or Caperton, the court has explicitly ruled that if a judge has a financial stake in the outcome, even indirectly, right? Or if there is a high probability of bias, it violates due process.
Okay.
The procedural chain you were describing assumes a neutral system that will just self-correct when a logical error is pointed out. But the source material highlights a massive, often unchallenged reality. Courts are frequently compromised by structural financial incentives.
Ah, you were talking about what the material calls downstream enforcement revenue.
Precisely. We are talking about court fines, administrative fees, probation contractor payments, jail housing revenue, and, intense clearance rate pressures.
Right, the business side of it.
Exactly. If a municipality relies on traffic tickets and supervision fees to fund its agencies, or if a judge is evaluated by administrative performance metrics, meaning they have to clear 50 cases before lunch, the tribunal is fundamentally not neutral.
I see where you're going.
Yeah.
Asking a judge who is under the gun to clear a docket whether a statement is an allegation or a finding is going to be treated as an annoyance, not a constitutional hurdle. They aren't going to pause and reflect on your brilliant procedural question.
You think they just ignore it?
Absolutely. They will simply rubber stamp the findings to keep the conveyor belt moving. They will say, I have reviewed the report, I am satisfied, we are moving on. The structural incentive just completely overrides your procedural checkpoint. But wait, hold on. The material gives us a highly specific, practical remedy for exactly that kind of judicial stonewalling. We have all seen it. The judge gives you a dismissive garbage answer. They say, because safety, or because it's standard practice, or exactly what you just said, because I am satisfied.
Right.
The instruction here isn't to get emotional and argue with the bullshit answer directly. The strategy is to calmly translate their dismissal into a procedural deficit on the permanent record.
But how does translating it stop the judge from just ruling against you anyway?
Because you are pitting them down for the review. If the judge says, because safety, the layman doesn't say, that's unfair. The layman says, what specific safety issue exists and what specific facts on the record support it.
Okay, putting it back on them.
Exactly. If the judge says, I am satisfied, the layman counters with, what facts is the court satisfied establish the required standard? You just keep handing the procedural deficit back to them. And let's be real, sometimes the judge will just tell you to shut up.
Oh, guaranteed.
They will literally say, not another word. But when that happens, the material is very clear. You never fight that command emotionally. You comply, but you mark the moment. You say, I asked that the record reflect I attempted to object and was not permitted to state the grounds.
Which builds a record for an appeal.
Exactly. It's all about preservation. Federal Rule of Evidence 103, for instance, is built entirely on this principle. In plain English, a reviewing court needs to see three things: that the issue was raised clearly, that the trial court had a chance to fix it, and that the trial court ignored it and ruled against you anyway.
Right.
If you don't do that, the appellate court just assumes you waived your rights. By constantly asking about the authority, standard, and facts, you are building a bulletproof record for the appellate level. You're proving you weren't given a fair hearing.
And that right there is exactly where your framework hits a massive brick wall.
How so?
Relying on a reviewing court assumes the appellate level isn't part of the very same institutional structure, but they are.
Well, they're a higher court.
Sure, but the appellate court is looking at the same municipal funding mechanisms, the same budget deficits, and the same administrative pressures. They are part of the state machinery. If you politely document a stonewall and just hope an appellate judge is going to care that a magistrate skipped a procedural plank, you are going to be deeply disappointed.
So what's the alternative?
Instead of just documenting the abuse, the layman has to attack the root cause of the stonewalling right there in the trial court.
By doing what exactly?
By filing what the material calls a motion for disclosure of pecuniary interests, structural financial incentives, and findings regarding neutral tribunal.
Wow, that is quite the title.
It is. And this isn't just a guy standing up and shouting that the system is corrupt. It is a highly formalized, heavily structured legal demand. It forces the judge to disclose on the written record whether any court, municipality, or third-party contractor receives revenue connected to this specific type of case.
That's intense.
It asks point blank if there are case volume expectations or clearance rate pressures that the judge is subjected to.
Hold on. I need to stop you there, because I have to admit some serious practical confusion about this approach. Let's go back to our layman scenario. I'm a terrified guy standing in front of a judge over a loitering ticket or, a minor zoning violation.
Okay.
The hearing might only last 5 minutes. If I hand the judge a piece of paper demanding to know his financial incentives and basically accusing the town of running a profit scheme, isn't that judge just going to hold me in contempt?
It's a risk.
I mean, doesn't demanding complex financial disclosures in the middle of a routine hearing alienate the judge and drastically worsen the layman's immediate situation?
It is absolutely an uncomfortable maneuver. I am not denying that. It takes immense courage, but we have to be honest about the reality of the situation here. You are worried about inviting hostility, but the hostility is already there.
Is it though?
Yes, it is just currently masked by bureaucratic indifference. They are smiling at you while they process you into a debt trap. Yes, asking about the scope of a condition is a safer, more standard question. It fits the language the judge expects. But if the tribunal is fundamentally compromised by an institutional revenue path, playing it safe guarantees you will be processed.
But challenging the procedure is something the court has to recognize under their own rules. A motion demanding the judge's financial background feels like, a nuclear option.
It's a nuclear option because the threat is nuclear. Think about how these financial mechanisms are actually triggered in the courtroom. They are triggered by what the court broadly labels as standard conditions.
Right, standard conditions of probation.
Yeah, a judge slaps standard conditions on your probation. Suddenly, you have to pay for a mandatory anger management class run by a private contractor. You have to pay a monthly supervision fee to the probation office. You have to pay for mandatory drug testing.
The fees add up fast.
Exactly. These aren't just lazy judging, they are administrative revenue paths. Supervision fees, monitoring costs, treatment program fees. These are the exact structural incentives that require conditions to be as broad as possible in the first place.
Right, but my argument is that you stop those conditions from attaching by demanding the factual bridge. When a judge tries to impose a standard condition, like, say, mandatory drug testing for a loitering ticket, the layman must ask, how is this condition narrowly connected to the specific risk the court has found? But let me just finish. You force them to connect the real-world fact to the power they are trying to exercise. If the only fact established is that you are standing outside a store, that does not automatically justify a blanket condition that triggers future supervision fees and testing. The procedural fix is the immediate shield.
Okay, and my point is that if you just ask how the condition connects to the risk, the judge will simply invent a broader risk to justify the condition.
You think they just make something up?
Why wouldn't they? Because the system needs the revenue from the monitoring provider. The probation department's budget literally relies on a certain number of people paying those monthly fees. A condition leads to supervision. Supervision leads to inevitable technical breaches, like, missing a phone call, which leads to breach allegations, warrants, and more fees.
It is a vicious cycle.
It is. You cannot effectively challenge the scope of a condition without challenging the financial mechanism behind it. If you don't force the court to make findings regarding its neutrality on the record, review becomes impossible because neutrality is just legally assumed.
I see the logic, I really do. But I still think it skips over the foundational mechanism of how power is actually applied in that room. Power does not exist in the abstract. It appears at very specific conversion points.
Conversion points.
Yes, a complaint is converted into a fact. The state's fear is converted into reasonable fear. A police report is converted into unquestionable evidence. A judge's personal discretion is converted into a binding order. If a layman does not challenge those specific micro-conversion points in the moment, no appellate court is ever going to care about a macro-structural argument regarding municipal revenue.
But the conversion points are exactly where the systemic bias shows up.
Yes, but you defeat the bias by breaking the conversion point. Let's look at what the material calls the paperwork self-proof problem. This is huge. The state brings in a piece of paper, a report, a complaint, an affidavit, and the court just treats the paper as reality. It magically proves itself.
Happens every day?
The procedural counter to this isn't to yell about the budget. The counter is highly specific. You say, I acknowledge this paper proves that someone wrote it. I'm asking what independent evidence proves the contents are actually true.
That is a great line.
System is financially corrupt to point out that a piece of paper is hearsay. You turn their automatic conclusion into a question of authority, standard, facts, and findings. That is how legal theory becomes a usable, tactical weapon in the moment.
I don't disagree that attacking those conversion points is vital. It really is. But you are treating the conversion points as if they are innocent procedural mistakes that the judge will correct once you point them out.
Not innocent, just procedurally flawed.
But they are not mistakes. The blending of official roles where the clerk, the prosecutor, and the judge all operate as a single administrative unit is exactly why the paperwork becomes self-proving in the first place. They are operating a conveyor belt together. If you only ask what evidence proves the contents of the paper, the judge, acting under those administrative performance metrics, will simply look down and say, I am accepting the report as evidence and move right past you.
And then you mark the record that they accepted an unverified report over your objection.
Which brings us back to what makes a hearing meaningful. Due process under the Constitution requires a hearing at a meaningful time and in a meaningful manner. If the outcome of your hearing is pre-decided by case volume incentives or downstream revenue needs, the opportunity to be heard isn't a legal proceeding at all. It's just a ceremony. It's theater.
That's a bleak way to look at it.
Raising the neutrality and financial incentive issue preserves the deepest constitutional flaw in the entire proceeding. It documents for the record that the individual was administratively processed, not legally adjudicated.
You know, this actually brings us to the most powerful tool provided in the source material. It's the true aha moment for anyone trying to navigate this nightmare. And I think it bridges the gap between our two perspectives.
You're talking about the paragraph.
Yes, the material provides something called the master courtroom paragraph. And it is brilliant. It is a synthesized script that acts as a linguistic shield against the machinery.
It really is the crown jewel of the material because it forces every single one of the system's assumptions out into the open.
Let's actually break it down, because every word in this paragraph is doing heavy lifting. It starts like this. I am trying to understand and preserve the process clearly. Right out of the gate, you aren't being hostile. You aren't yelling about your rights. You are establishing yourself as someone engaging in procedure.
So important.
Then the hammer drops. I object to allegation, conclusion, or report language being treated as established fact without the legal and factual foundation being identified.
That sentence alone is a masterpiece, because what does it do? It stops the conversion point dead. It tells the judge, I see you trying to turn that police report into a proven fact, and I am formally objecting to the alchemy.
Exactly. And then it delivers the chain reaction we talked about earlier. I ask the court to state the authority being used, the standard that applies, the specific facts relied on, the findings being made, and how the requested order is narrowly connected to those findings.
It's all right there.
In one breath, you have forced the court to build the entire bridge, plank by plank, on the permanent record.
And if they refuse to answer, or if they give you a bullshit answer, their refusal is captured on the record. It is incredibly potent. Whether you are using that paragraph to challenge the factual basis of a standard condition, as you suggest, or whether you use it to set the stage for challenging the institutional revenue path of the tribunal itself, as I suggest, you are doing the exact same essential thing.
Which is?
You are demanding that unaccountable power justify itself in writing.
I love that. We might disagree on the scale of the solution, but I think we absolutely converge on the foundational premise of this source material. The absolute biggest mistake any human being can make is trying to convert their truth into justice without building a procedural bridge.
Absolutely.
We both agree that walking into a courtroom and arguing moral truth, displaying righteous emotion, or launching into broad constitutional theories is a fatal error. The tank will run you over. Your focus must be relentlessly, strictly on process, on evidence preservation, and on creating reviewable issues on the record.
I couldn't agree more. The quiet, structural issues, Things like the delegation of authority, the actual integrity of the written record, the sufficiency of notice, and yes, the hidden financial incentives of the tribunal. These are deep, deep wells of legal strategy that rarely see the light of day because people are too busy yelling about fairness.
Right.
You have to stop arguing about what is fair and start arguing about what is permitted by the rules.
The material offers so much more to explore in these mechanics, from handling administrative overreach to dissecting exactly how courts establish jurisdiction. Ultimately, we leave it to you, the listener, to decide how to approach your own defense.
Yep.
You have to decide whether your best path lies in meticulously mastering the micro-procedural planks of the legal bridge, or if you must step back and confront the structural toll collectors demanding payment at the other side. You cannot fight the tank with poetry, but it is up to you to decide exactly which wrench to throw into its gears.